So today we're going to be reviewing intellectual property, and we are very lucky to have Karen Durrell from Miller Thomson with us. Actually, she does specialize in IP with Miller Thomson, being the intellectual property. She is also a registered patent agent. She has experience mostly with technology companies, but has been working with a variety of other firms as well. And so definitely save your questions until the end of the presentation. And at this point, I'll pass it on to Karen. Thank you.
Thank you very much, Carla. Welcome to everybody who's joined us today. As has been mentioned, I'm going to talk about intellectual property in the context of businesses. And one of the things I want to start by saying is that my references are going to be to Canadian intellectual property law. It's not exactly the same as intellectual property law in some other countries, but we're going to talk about it at a very high level. So some of the aspects will be identical to what happens in some other countries, and it will give you a general sense of what each of these different types of intellectual property that we're going to talk about really are all about. So to start off, I wanted to point out that intellectual property is often used as a term that's synonymous with patents. But there are many different types of intellectual property, not just patents. This first slide shows some of the different types of intellectual property that exist and gives an umbrella as a symbol just to sort of show that the term intellectual property is really an umbrella term with lots of just different categories of types of protection that sit underneath that umbrella. So we're going to discuss some of those different types of protection, not all of them, but some of those that are most important to businesses today. Next slide. Next slide, please. Thank you. Okay, so one of the things we want to talk about intellectual property, all types of intellectual property, is that what can be protected is not just a general idea. Lots of people think that you can protect ideas in their pure form, and unfortunately that is not actually true. What you need to do is you need to reduce the idea from its purest form into some type of tangible item, whether it be a drawing or it be an invention or it be a trademark. You need to take it from the idea stage, put it into a tangible stage, and then for some types of intellectual property, you further need to create specific types of protections, and to do that you have to make specific types of filings. So we're going to talk about the differences between the types of intellectual property once you've brought them to a tangible level, about how you would get actual protection for some of these. Next slide, please. So one of the things I also want to touch on before we talk about the different types of intellectual property are some of the myths that exist out there about intellectual property generally. These myths include things like all intellectual property is the same, which we just discussed, that is not necessarily true. Another myth, of course, being that intellectual property protects ideas. Again, we've just touched on that pure ideas are not protectable as intellectual property. And also the idea that intellectual property rights give you some kind of international protection. Generally, this is not true. There are some exceptions to this rule, but you should not think that when you have an intellectual property right that you necessarily have it in all countries around the world. Generally, you have it in the country where you have actually sought protection. But again, we will get into that as we start to discuss each of these different types of intellectual property. Next slide, please. So the first type of intellectual property I'd like to talk about is copyright. Copyright is protection for works that are expressions of ideas. So this slide gives you an idea of some of the different types of works that can be protected by copyright. We've got the Nike swoosh, which is a logo, it's a drawing. We've got an indication of original work. We've got music, we've got photos. Some are listed also, software code, manuals, drawings, layouts, the PowerPoint slide, website designs. All of these things can actually be protected by copyright. Copyright in Canada, there is no requirement to register copyright. It's a right that automatically comes into being as soon as you have completed a work. So as soon as you've taken a picture or as soon as you've finished creating a written work. That's why a lot of companies own copyright and may not even realize it because they think we haven't actually filed to ask for any kind of protection, so therefore we must not own any intellectual property. in the world of copyright, you can automatically own protection for these types of works as soon as you have completed the work. Generally, first ownership in copyright is granted to the author of the work. This is not always the case, but that's a general rule. And the right that is granted is a sole right to produce or reproduce a work, perform a work in public, to publish a work, to prevent others from copying a work without permission. Copyright, because you do not actually have to register it, it is considered to be a right that crosses international borders. So that if you have copyright in a work in Canada and you take that work into the US or another country, you will likely also have copyright protection for that work in that other country without you having to do anything. But the difference is that the copyright protection you have when you are in Canada for a work will be based upon the laws that exist for copyright in Canada, whereas the copyright protection you will have in other countries will be in accordance with the legislation for copyright in those other countries. Copyright legislation is not the same in all countries. In Canada, you have a right for generally, and again this is not always the case, but generally for the life of the author of the work plus 50 years. In some other countries, that term changes. Some things to also be aware of that are different between copyright laws in various countries is that in Canada, for instance, you will have what is called a moral right, or the author of the work will have a moral right. This moral right is a right in the integrity of the work and a right to be associated with the work. So for instance, if you have created a book, then you would have the right to always be listed as the author of that book, because that book is your copyrighted work. Even if your copyright is then sold or otherwise transferred to another owner, that owner does not buy or receive in any manner the moral right. The moral right always remains with the original author of the work. So it's a little bit of a confusing kind of concept, but it is also something that doesn't exist in all countries. Not all countries extend moral rights. If you want to make sure that someone who is an author of a work that you are purchasing can no longer use their moral right, then you need to have them waive that moral right. And that's a consideration for when you are purchasing copyrighted works from other people. You will want to know that the author has waived their moral right, or else the author will continue to have a right of integrity in the work and a right to be associated with the work, and they have the right to ask for that in the future. Copyright is not a one-size-fits-all type of protection. As mentioned, it covers all kinds of different types of works, and those works can each have slightly different types of protection. For instance, a sound recording may have slightly different type of protection than a performance or a book or a photo. The other thing to mention about Canadian copyright is that we are in the midst of having a series of suggested new copyright laws put before our government, and we are very, very soon going to have a new Copyright Act, so some of our laws in this area will be changing, so that's something to keep in mind. Next slide, please. So in Canada, the copyright test used to be, is the work original? So has someone else created this work, or is it your own? That test has changed, just so that people know. It's a test that is based upon whether there was skill to create the work, judgment in creating the work, and whether the creation of the work was more than purely a mechanical exercise. So it's not just, is the work original? And this is based upon case law that came out in 2004. So now moving on to trademarks and branding. This is another type of intellectual property right that can be very important for businesses. This is really protection for a mark, which might be a word mark, it might be a symbol, it might be a design. Here are some examples on this slide of some different types of trademarks. Trademarks need to be registered in Canada. Generally, the trademark is granted to the applicant, although trademarks can be assigned or sold to other owners down the line. And the right that's granted in a trademark is the exclusive right to use the trademark throughout Canada in respect to particular wares or services. And those wares or services, and it can be wares and services, will be listed in your trademark application and will be listed with your registered, any kind of registration that's granted based upon your trademark application. Again, when you have a registered trademark, if it's granted by Canada, that's only good in Canada. It's not good in other countries. Your protection will only extend to the limits of the Canadian border. And the term in Canada for a trademark is 15 years. And at the end of that 15-year period, it will be renewable for additional 15-year periods. Again, the laws for trademarks in other countries can be slightly different, including the term can be slightly different than the 15 years. But in Canada, if you have a trademark, that's how long you will have your right for. So another type of protection that's well known, probably the best known type of intellectual property protection, is patent protection. So this slide just gives you an idea of what a patent, at least the front page of a U.S. patent, will look like. It will have information about the filing, it will give you the title, it will have information about, or short synopsis of what the invention is all about. Patents are granted for an invention that is novel, that is not obvious, and that has utility, which basically means in most countries that your invention has to work. Also, an invention will only be granted patent protection if it is within what is known as patentable subject matter, and this can be slightly different in country to country. For instance, in Canada, a game is not considered to be patentable subject matter, although in other countries it may be. Higher life forms are not patentable subject matter in Canada. Again, that can be different in other countries. So you have to fit these 4 criteria. You have to have something that's brand new, no one's ever done it, that it wasn't obvious to do to someone else who's skilled in the art area of that invention, and it has to work, and it has to be subject matter that can be the basis for a patent. What having a patent offers you is the exclusive right, privilege, and liberty of making, constructing, and using the invention and selling it to others to be used within the country where you apply for the patent application, where you file your patent application. Again, just like trademarks, if you file a patent application in Canada and you are granted a patent, your protection for that granted patent is only within the borders of Canada. The term of a patent that is granted in Canada will be 20 years from the date when you first filed the patent application. Now, one thing to be aware of is that the date between filing the patent application and when the patent may be granted can be several years between those 2 activities happening. So it can be a lengthy process to have a patent granted. Some other things to remember about patents is that there is a grace period in Canada and in the U.S. whereby you can make public disclosure of your patent, of the invention that you want to have be the subject matter of your patent. But if you make public disclosure, you have to file your patent application within 12 months of making that disclosure. So there are things to be keeping in mind if you are a business that's based on inventions and you want to seek patent protection for your inventions. You do have a time limit to do so between the time when you let anyone know about your invention outside of your own business and the date when you need to file your patent application. So keeping that in mind, another concept or idea that you should be integrating into any looking at wanting to get patent protection for an invention is if you are going to disclose it to anyone, you may want to do so under confidentiality, which means you may want to have the party sign a non-disclosure agreement before you ever disclose anything about your invention to said party. So confidentiality is important in the world of patents, basically because you want to make sure that you don't put your invention information out there in a manner that then blocks you from being able to have patent protection over it at a later date. Okay, another thing to keep in mind is that it was all the rage a few years ago to file patent applications for business methods. The rules for business methods in the U.S. and in Canada are not the same. So if you want to file a patent application for a business method, you may be able to do so in the U.S., you may not be able to do so in Canada. Again, this is just an example that some of the Canadian rules for intellectual property are not the same as the rules that you'll face in other countries. So another type of protection for intellectual property that is related to patents is an industrial design. In Canada, we call these industrial designs, and in the US, they are actually called design patents. That's why they're thought of as being sort of similar to patents. An industrial design gives you protection not over the function of a product, but will give you a protection over the aesthetics, so the way that it looks. So the example here is a shoe that has a specific look to it. You may be able to get protection for the look. So if you have a product that has a unique look, you may want to seek industrial design protection for it. Another idea that I just wanted to bring up to you about intellectual property protection are trade secrets. Trade secrets are a type of protection that you can receive for aspects of your business or of any of your products that you keep secret, that you take measures to make sure it remains confidential. So one of the things you need to keep in mind if you are deciding that the way you want to protect your ideas is just not to tell anybody about them or protect your products, so on and so forth, is that you need to make sure that if you have a product and you're going to put it out there on the market and there is some aspect of it that you want to protect through confidentiality and therefore protect the trade secret, that cannot be reverse engineered, which means that someone who receives your product or purchases your product can't just take your product apart and figure out how you did it and recreate the product. If that is the nature of your product, then trade secret protection is not going to be of any great use to you. A famous example of a trade secret is, of course, the Coke formula for Coca-Cola, the drink. That recipe has never been patented. It hasn't been protected in any other way. It is kept under strict confidentiality, and therefore is kept as a trade secret, and that is the protection that Coke has for it. So trade secrets, depending on the type of product can be quite useful. So these are various types of intellectual property rights that can be very helpful to a business. And the one thing that a business needs to really think about is what types of intellectual property do you actually own, and what can you do with those types of intellectual property? So a good starting point is to make a list of what you own. Also make a list of the type of intellectual property that you may want to own in the future, whether that be patents for various inventions that you're coming up with. Maybe it's trademark protection for various marks that you want to use as brands for some of your products in the future. But you really should sit down and think about your IP strategy for your business, because that can be very important. So some of the options that you may want to consider when creating an IP strategy include, as I first said, creating an IP database, which means you sit down and you think about what you have and you actually lay it out in a database. Some of these are set up in the next slide that I have, which will appear just in a second. Oh, sorry, it's not on there, so I'm just going to run through these. Another idea to think about is if you are going to look for patents, how do you want to protect these? Which countries do you need to have patent protection in? Are you going to take any contractual protections for any of your intellectual property, for instance, having a non-disclosure sign before you make disclosure of any of the ideas that you have going on in your company, or any of the innovations that you're coming up with that might be the basis for a patent protection. You want to look at, are you using any open source? Often companies that are working in the world of information technology may be using some kind of an open source software. How are you integrating that into what you own? Do you have the rights and the right contracts for those types of rights? And then the last thing you want to think about is whether you want to register for intellectual property protection or not. So these are just some considerations that you can have to think about in terms of putting together an IP strategy. So I really didn't have a lot of time to get very detailed into any of these ideas today, but I wanted to give you a high-level overview. And so if you have any questions based upon anything we've discussed, please go ahead. I'd be happy to answer them.